This is the Litigator's Edge podcast with your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, a podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadio. It's such a privilege to have Jon Stern as my guest today. Jon is a partner at Victor Rein, a national litigation firm with multiple practice areas, including civil litigation, labor and employment, white-collar criminal defense, and today's focus, aviation law. Jon, thank you so much for being here today.
Thank you for having me, Aniket. I'm happy to be here.
Thank you, Jon. I'd like to start by please asking you to share a fun fact or a cringe joke for our audience. Which will it be and what is it?
So I'm going to go with a fun fact because a cringe joke would make people cringe. And the fun fact is that my very first appearance in court as a lawyer was only 6 days after I was admitted to the bar. And that appearance was to argue an appeal in the United States Court of Appeals for the 10th Circuit.
Wow, that's a pretty fast initiation into the field of legal practice. Just so quickly after the being admitted to the bar. That's wonderful. On that same note, Jon, I like to think of every attorney who makes the time to be on this show as a superhero, and every superhero has an origin story. What's yours?
So let me first say that I reject the superhero label because I think we are all human beings and we all bring certain backgrounds and skill sets to the practice of law. And while it does require dedication and a great deal of hard work, in fact, I would say I'm working just as hard now as I was at the beginning of my legal career, I don't think it requires superhero skills. But that said, let me get to your question, which is, how did I get into the practice of law? And it's somewhat of a long story. When I was 13 years old, my father was interviewed for a company publication, and he was asked about his kids. I have one brother. So he described my brother, who was headed for engineering school. And when he got to me, being the younger brother, he said that Jon always argues with me and his mother. So we have thought that he would probably do well as a lawyer. Now, that wasn't where my head was at the time. As a teenager, I'd become very interested in airplanes and flying. And my goal was to become an airline pilot. So when it came time to go to college, I started out at the University of Wisconsin in Madison, but quickly realized that I just didn't have the motivation for that program, but I knew what I wanted. And so I transferred to Embry-Riddle Aeronautical University. And there I did the flight training. I got all of my licenses and ratings. I became a commercial pilot. I was qualified in single engine airplanes, multi-engine airplanes, instrument flying. I became a flight instructor, also in single and multi-engine airplanes and instruments. And as I got closer to the end of my college stay, which was just over 4 years, I put in applications with some of the airlines. And this was 1980, beginning of 1981. It was not a good time to become an airline pilot. At that time, there weren't a lot of openings. And what openings there were, a majority of them were going to ex-military pilots. So at the time, that was kind of the pipeline for pilots to get to the airlines. They went through military training, they flew in the military, they left the military, they went to the airlines. I didn't get any bites from my applications. And so as a backup plan, I'm like, okay, what am I going to do if this doesn't work out? I put in an application with the Federal Aviation Administration to be an air traffic controller. The date of August 3rd of 1981 is kind of an important date in my origin story because that was the date I was 3 months away from graduating from college. I graduated in December. And that was the date that the Professional Air Traffic Controllers Organization, which was the union of air traffic controllers, went on strike. And going out on strike, not showing up for work, was illegal. Ronald Reagan was the president at the time, and he said, back to work. He ordered the controllers back to work. Well, there were about 13,000 PATCO members, air traffic controllers at the time, and more than 11,000 of them were fired as a result of not returning to work. Well, guess what? Suddenly I had a job. And I didn't just have a job anywhere. I had a job at what they called a level 5 air traffic control facility, which is the highest level, either the most traffic or the most difficult, at Washington National Airport, years later named Ronald Reagan Washington National Airport at DCA. So I went to work as a controller at DCA, which at the time had both the control tower, the glass cab that you see when you're taxiing around the airport. It also had a TRACON, which is the Terminal Radar Approach Control Facility. The controllers there rotated through both the tower and the TRACON. And I had completely qualified in the tower and was completing my training in the TRACON and started thinking, I like what I do, but I don't feel like I'm going to be gratified spending my career doing this. And so I started thinking about options. At the time, I had a very dear and have a very dear friend, Cheryl Hepfer, who is an internationally renowned matrimonial lawyer who practices in Maryland. And I had taught her to fly. She got her private pilot's license through my training. And she was trying to persuade me to go to law school. And she did. She did. So I made the decision to go to law school. And so that's how I got that far in my origin story. So Cheryl warned me. She used a famous quote from Justice Story. She said, "The law is a jealous mistress," which I'm not sure I understood at the time, but it meant the law is pretty all-encompassing. And, I think breaking it down, what it means is it's a challenge to find a work-life balance as a lawyer. And Justice Story was right about that, and Cheryl was right about that. And so it's been a constant challenge throughout my career to make time for family, to have some things outside the law that interest me. So I went to law school knowing that I wanted to be an aviation lawyer, but I didn't really know what that meant. I didn't know what it meant to be an aviation lawyer, but obviously that was what I was going to be. So I did, during the course of law school, get some direction because I spent 2 of my summers working at the Department of Justice. And the Department of Justice had and still has an aviation unit. It's actually aviation combined with admiralty. And today it's aviation, admiralty, and space. At the time, it was euphemistically known as Splash and Crash. So I spent 2 summers at Splash and Crash. And then upon graduation from law school, I entered the Justice Department through their honors program, and I became a trial attorney for Splash and Crash at the Department of Justice. So that's that's the origin story.
That's wonderful. What I especially like about that I like a lot of things about what you just shared, and I'm sure our audience will as well. But I like the fact that you taught the matrimonial lawyer how to fly, and she taught the person who knows how to fly, or she inspired the person who knows how to fly to practice law. So that's just a wonderful exchange of ideas and inspiration. Um, uh, Going to what you actually do in your law practice, because aviation law is such a specialized field that I would love for our audience to learn more about it. What does a typical day in the life look like for you? What are the types of matters that you handle?
So Our firm has a pretty broad aviation practice, but it's an aviation litigation practice. So, when I said I didn't know what aviation lawyers do, they do a lot of different things. They could do regulatory work. They could deal with slots at LaGuardia Airport or busy airports. They could do aircraft financing for purchases of aircraft. They could do the closings for actually buying and selling airplanes. But what we do is we do litigation, generally arising out of aviation torts, sometimes out of transactions, sometimes out of other commercial matters related to aviation. But the core of it is really doing the bodily injury and property damage work associated with aviation risks. And so what is a day in the life like? We do a lot of writing. There's a lot of analysis, legal research. Our cases, for good or for bad, there's a pretty high rate of resolution without trial. So obviously the goal, and where it's a realistic possibility, the goal is to get a case dismissed either at the pleading stage on a motion to dismiss or at the summary judgment stage. But if cases aren't resolved through that, then often they're resolved through settlement. And I would say, maybe 2 to 5% of our cases go to trial. So what's the difference between a litigator and a trial lawyer? I guess a litigator is someone who is always preparing cases for trial, but rarely gets to try them. A trial lawyer is a criminal lawyer or an automobile injury lawyer who's in court all the time trying cases.
Got it. Thank you for sharing that, John. Going back maybe a couple of decades in your career, you've handled some incredibly significant matters, including complex covers for insurers from the 9/11 attacks, which I imagine must have been quite a challenge. I had the privilege of going through some of your work, including an article where you take the helm of a 757 in a flight simulator along with this journalist and trace a probable path for Flight 93. So a few questions on that. One is, can you speak a little bit more about that specific experience? Two is, what were some of the more unique legal and human complexities that you navigated in your work on 9/11? And then three is, how did these experiences, shape you as a litigator?
So, first of all, the article was in the Washington Post, and it was written by a good friend of mine, Bill Sternberg, who had a long career in journalism. Ultimately, he was the editorial page editor for USA Today. The article came about because that was an idea he had long been toying with. He wanted to write a piece on where was that aircraft that crashed in Pennsylvania headed? Was it headed for the Capitol or was it headed for the White House? And so he had discussed that with me, and I gave him my perspective solely from viability of, what could a person who had minimal pilot training do in terms of taking an airliner and getting it to one of those targets. And my conclusion was the Capitol was the much more likely target. And we used my flight simulator to demonstrate why that was so. And actually, in the Washington Post article, which was in the Outlook section on a Sunday, they had a bunch of pictures, including screenshots from the simulator that made it quite clear why the White House would be a very difficult target. The Capitol would be much easier. 9/11, my role in the 9/11 cases was entirely dealing with insurance coverage issues. So I was not involved in that ongoing litigation involving the property damage and deaths that occurred from the 9/11 attacks. My role was in analyzing the insurance coverage available to a variety of significant players in that horrible event. So I didn't have the interactions that someone like Ken Feinberg, who was the special master assigned to pay out the fund that Congress created to resolve most of those cases. I've had lots of human interaction experiences in other cases where I'm dealing with very sad and difficult subjects and horrible losses, but probably for good. I didn't have that with respect to 9/11.
And final question on that: how did those experiences, even in dealing with matters on such a scale and have with of such national import, how did they shape you and your career as a litigator?
I don't know that those shaped me any more than some of the smaller scale cases. In fact, I might say that when I had cases where there was more human interaction, where I'm taking depositions of people who have lost loved ones, those probably had a greater effect on my career and how I interacted with people than the insurance coverage work. The insurance coverage work, particularly involving such tremendous numbers that 9/11 involved, just required meticulous amounts of detail in analyzing every issue and kind of turning over every rock and scraping all of the pieces of dirt off it in a way that you don't get to do when you're dealing with smaller matters.
Understood. Going to a more recent matter that you've shared on your profile. There was recently a major airline that had an in-flight catastrophic engine failure, and you were a key party in the defense of that airline. Can you maybe speak to that experience, the strategic mindset that's required to manage such a case from the immediate response through to resolution?
So part of that is that when you're dealing with those bigger cases, it's a real team effort. And so big picture, it's coordinating a team of professionals, making sure that you do what you need to do, but also making sure that you're not duplicating efforts across the team. That case, we managed to resolve all of the claims. We had lawsuits. We probably had out of something like 50 claims that were made, we probably had 10 go into litigation, but none of the lawsuits went very far. Everything was settled. And that's the goal when you're representing the airlines or other people involved in those types of big cases. The goal is to settle them if you reasonably can. And so we achieved our goal. We got all of the cases settled, and that case was put behind everybody involved, including our airline client.
Got it. Taking a step back, John, and looking at your prior experiences, obviously as an air traffic controller, your work at 9/11, as a flight instructor, you've also written amendments to the federal aviation regulations as well. So how do all of those experiences inform your approach to litigation? How does that all play into how you think and advocate for your clients?
Sure. So obviously, we are all a bundle of experiences that we bring to whatever we do. I happen to have some very relevant experiences to what I do on a daily basis, having been an air traffic controller, a pilot, a flight instructor, having consulted to the FAA, helping them write regulations. These are all things that inform my base of knowledge when I go into a case. So I would think that that gives me a better kind of holistic understanding of what I'm dealing with in a given operational situation that I might be dealing with in a litigation. There are quite a few very talented attorneys in our space who don't have that background, who develop organically just as litigators and got to the point where they can very ably handle these cases too. But I like to think that it gives me an advantage, and when I come to a case, I can very quickly see things that maybe other people won't see. And
Right.
the other thing is a big part of our practice is dealing with expert witnesses, either our own experts or opposing experts. And I feel pretty comfortable when I'm taking depositions of pilots or air traffic controllers it's not quite how I feel when I'm taking the deposition of an orthopedic surgeon. That I really have to cram for, and I don't have the background. But with the aviation professionals, I don't have to do a lot of prep to have a pretty good understanding.
That's great. I can imagine that being quite the advantage in those situations. Switching gears a little bit, John, to innovation and technology. So, how has technology in general changed your approach to preparing for the matters that you do over the decades that you've been practicing in this field?
So, as I thought about the technology component of our talk, I realized that we really have to go back pretty far because people like to talk about technology like it's a new thing that suddenly we have technology in 2021, 2022. But technology started long before what we call AI today, right?
Mhm.
So let me tell you, if I may, how I found the practice when I first started and how I've seen that shift over time. So first of all, let me go back to law school. When I was in law school, they did have Lexis and Westlaw, but they had these dedicated terminals. So, as I recall, Lexis had a red machine that you used to access Lexis. And I don't remember what the Westlaw terminal looked like, but it was a dedicated terminal. And personal computers were just so at the time I was starting law school, that was the day of the Apple II computer. I had a Commodore 64 during law school. That's what we go back to. And the use of the personal computers was not widespread in business and certainly not in law firms. So step ahead the 3 years. I'm out of law school now and I show up at the Justice Department. And they were ahead of their time. The office that I worked in was headed by a guy named Mark Dombrov, who saw to it that the lawyers in his office all did have personal computers, which was somewhat necessary because we didn't have very many secretaries. So I got a taste of personal computers, which at that time, this is the other thing. People think, oh, you had a personal computer, so you had spreadsheets and email and word processing and whatnot. No, we had probably Lexis and a basic word processor. I don't remember what we used at the time. It wasn't Microsoft Word. And then a couple of years later, when I went into private practice, I showed up at the firm and the attorneys did not have computers on their desks. So, it's so strange to think about today when I spend much of my day in front of a computer, but back then we didn't even have them. We had a word processing pool that used these Wang word processing machines. And so over time, the personal computer became more widespread. And lawyers, not all of them, but for the most part, lawyers got PCs on their desk and their capabilities expanded over time. I mean, I was pretty far into my career before we were using email to communicate. And the other thing that changed early in my career was the widespread uh, availability of fax machines. That was, most people think, oh my God, things really changed since you did everything on paper. Now we get everything in email. Well, the real change came with the fax machine because the fax machine was what created client expectations of virtually instant responses, right? So the fax machine was actually a significant technological development in my career that changed the way we practice. Not so much from the things we do, but the pace at which we're expected to
Mhm.
do them. And so some other technology features along the way. I've been an avid flight simulator user for many years, going back to that Commodore 64 computer that I had. And I've integrated the flight simulator programs into my practice to, if I would get a case involving an aircraft accident, I could go out and I could familiarize myself with the geography, the topography, what things looked like, what the runway layouts looked like at an airport, what nav aids were there. I could go experience that in my flight simulator. Obviously, today it's 100 times more realistic than it was in 1983, but it's been a tool I've used throughout those years to do that. And it's also enabled me to create graphics that I've been able to use sometimes in some of my cases, but also in presentations that I've given at conferences. So that was a use of technology, and that's closely related to animation, which is a significant feature in what I do in aviation tort litigation. It started out when I was at the Justice Department. There was a terrible airline crash in Dallas, Delta 191. It was a wind shear accident. It was a DC-10 or a L-1011, one of those. And DOJ created an animation to use in the trial of that case. And that animation cost approximately $250,000 to make. Wow. It was, at the time, it was very advanced. If you looked at it today, it was probably pretty basic. Over time, those animations and the evolution of the technology, given Moore's law, where we're doubling the number of transistors on an integrated circuit every couple of years, those animations have become much less expensive to make, more widespread, more robust. So they're regularly used in our business. And in some recent cases, I've actually seen where they're going to the virtual reality goggles and creating an opportunity, if not for a juror to put on the goggles and experience. There was one case I was involved in where at trial, one of the experts, a pilot expert, put on the goggles, allowed the jurors to see what he was seeing on a screen while he was operating a helicopter. So that kind of use of technology has been developing and precedes AI. Here's another one. In 2008, I tried a case for America West Airlines, which America West became part of US Airways, which is part of American Airlines today. In that case, I had a couple of plaintiffs. It was a father and a son. And the father was a bit mendacious. And I used for the first time in that trial the trial director program, which is presentation software. It allows you, I'm sure many of your viewers know, it allows you to put up exhibits and play video clips and that kind of thing. But one of the great features of it for that trial and at that time was that you could use a barcode reader. And I always use a trial notebook. So in my trial notebook, I would have things I wanted the plaintiff to say, or other witnesses, but particularly this plaintiff who had the capacity not to answer honestly. And I had barcodes for each thing that I wanted to get out of this plaintiff, where if he deviated from what I wanted him to say, I had something ready where I could just pull up, and the barcode reader I had was a gun. So I would pull the gun literally out of a holster that sat on the trial table, and I would aim it at the barcode in my trial notebook, and it would trigger the playing of a video clip of him testifying contrary to what he said in the courtroom in that moment, or an exhibit that was something he had written that contradicted what he said in the courtroom in that moment. And what was so funny about it is that after a couple of times of pulling the barcode gun out of the holster, there was a Pavlovian response. His answer would change before I could even pull the barcode gun all the way up to aim it. So that was a great use of technology that goes back 17 years. The next step is predictive coding. I had a big case starting in 2010. And one of my partners at the time, a guy named Tom Grix, who had really become interested in predictive coding and e-discovery issues and had made himself an expert in that space. I put him on the team for this big case that we had. And we ended up being the first case in the United States to obtain an order allowing the use of predictive coding for our document collection, our document production, in the face of opposition from the other side. And the case was called Global Aerospace versus Landau Aviation. And what's funny about this is that historic order was one handwritten page.
Wow. That's a That's amazing. Thank you for sharing all of those stories, John. They speak to not only not only sort of the historic sweep of technology that goes far beyond the last 3 or 4 years, as you mentioned, but also to your strategic use of it. I especially like the barcode, because that's not just technology, but that's your strategic use of technology to drive towards a particular outcome, which is the literal definition of innovation. So thank you for sharing that. Um, looking at
I do have
Yes.
two
Oh,
more.
please go ahead.
So the other one that people seem to forget about is the transition that we went through back in the 2010s, where suddenly we went from having these massive file rooms to having everything online. It really was such a significant transition, and I didn't even realize it as it was happening, right? I mean, we have people coming in and doing our IT, and we're going to where our files become electronic. And then suddenly one day it dawns on me, I can do this from anywhere. And so I was one of the early people. It didn't take COVID to get me to stop commuting to the office every day. I did that 7 years before COVID. I had this epiphany. I don't need to be in the office to do this. um, Couple more audio transcription. We have all these audio files, particularly in our space. You know, we have recordings of radio frequencies and this and that, and voicemails. And I mean, we have so many tools today. It's remarkable to me that Microsoft Word has built into it the capability to simply upload your audio file into Word and it spits out this beautiful transcript. We used to spend a lot of money to do that. So another piece of technology. And then finally, AI. I mean, that's the big one everyone's talking about. And is it changing the way we practice? Yeah, it is. And my view is if you don't get on the wagon, you're going to get left behind. AI is a big technology change that will change the way we practice, has already done so, and will continue to do so as it improves.
Thank you for sharing that, John. What are some specific ways in which A, you use AI or your team uses AI today? And B, where do you see the AI train? What are the next 3 or 5 stations on the AI train, if you will?
So the way we use AI is currently it's very good for finding cases. So as I said before, we do a lot of writing in our practice. We pride ourselves in doing top-notch briefing. And whereas we used to, again, I could go back and tell you that I started out using books, digests, shepherdizing a case by pulling 4 different volumes of Shepard's to confirm the validity of one case. For a long time, using Lexis and Westlaw, we had the capability to find and read cases, but there was some degree of hit or miss with finding the right case because it was predominantly based on keyword searching. Now, got a little better. You got to a point where you could do fuzzy keyword searching, but basically you need to come up with the right combination of words and a little bit of luck to hit the case. Whereas I think the big change with AI in that area in terms of research and finding the right the right case or the right statute or the right law review article. Now it's become simply describing it conceptually rather than hitting on the right set of keywords. And so we use that to do our research and to find our cases, and it's good at that. It's not perfect, but it's good at that. The other thing that it's good at so far and getting better every day, and you know this because you do it in your company, summaries. It's really good at taking large document sets and summarizing things for you. And in a world, you can go to the Sedona project and see the number of multiples that are involved when a business goes from a paper system to an electronic system. And, you're talking about 50 or 100 times as much data as you had when you were paper-based. And it becomes totally impossible or impossibly expensive if you were going to do it for a human to eyeball all of the documentation. So the AI really helps you in finding the documents or summarizing the documents. And as I say, the AI is good at it, and I see it getting better every day. Now, I still try to eyeball the actual document. It's kind of the trust but verify, but it's exceedingly useful for that. And the other thing you can do with the document set, in addition to summarizing, is you can ask it questions. So I can upload a document set to my AI tool, and I can just ask, did anybody say something along the lines of X? And it goes through that document set in seconds and will point out to me, yes, that was said, and here are the 3 pages you'll find it on out of the 25,000 pages you uploaded to me. And what an enormous efficiency creator that is, to the benefit of our clients who don't have to pay reviewers to go through and extract that information. And just in terms of how one crafts a brief, it's so much better if I can do that on the fly and just ask that question while I'm writing, rather than wait a week for someone to give me the answer to that. So that's certainly a use of it. Let me just say this. I am not at the point where I use it to write a brief. It can do it. I would read every case that it cites and make sure it's accurate. It can do it, but it's not of the quality that I would be willing to put my name or our firm's name on. So will we get there? We probably will get there, but we're not there.
Understood. Jon, this has been a wonderful conversation. Just a couple more quick questions to wrap it up. So you've had a wonderful and diverse career in this very specialized field, with a lot of change both within the field and through technology and AI and all the other things that you mentioned. What advice would you give to an attorney who is maybe earlier in their career and looking to navigate today's landscape, in terms of legal practice, in terms of society, in terms of technology, and especially someone who's aspiring to a specialized field like the one you chose?
So the first one I would say is give yourself a break. There's no such thing as perfection. It's not achievable. Don't hold yourself up to that standard. Point 2, own it. And what I mean by that is, I don't care if you're the most junior person on the team. Take pride in what you've done. You're part of the work product. Don't turn it over to the next person until you can be proud of that work product. Don't take the attitude, oh, I know the senior associate is going to mark it up, so I don't have to polish it. No. Polish it. Be proud of it. Provide something that you believe is ready to go to the court or to the client. 3, live by the golden rule. Treat others the way you would want to be treated. Do that to people more junior than you on the team. Do it for the support staff. Obviously, do it for the people more senior than you on the team. We don't have, since most courts now have gone to electronic filing, we don't have that much interface with like the clerk of court. Early in my career, I'd go down to the courthouse to file things. Now it's all electronic. But on the occasions when you do get into the courtroom, there are a bunch of people who are in that courtroom working under the judge. Apply the golden rule to them. Be nice to them. It can only come back and help you. Those are 3 pieces of advice I would give a junior person starting out in this field.
Wonderful. Thank you so much, Jon. Final question for you. What is one question that I should have asked you, but I didn't?
You did not ask me how people can reach me.
Yes. How can people reach you, Jon?
They can reach me by phone at 202-545-7768 or at jstern@victorrain.com.
Wonderful. Thank you so much, Jon. On that note, we will wrap it up. I'm sure our audience will enjoy this conversation. I appreciate your time, and I hope to have you again on the show soon.
Thank you very much, Aniket. It's been a pleasure.
Thanks for listening to this episode of the Litigator's Edge podcast, brought to you by Threadio.